What are the sanctions for non-compliance with these export laws?
The sanctions, because national security is involved, the sanctions can be very severe. What I will tell you is that the sanctions are more severe on those companies that are knowingly in violation of the export laws, rather than those companies that make a mistake and don't realize they're subject to the laws. But the sanctions can be as high as $250,000 per instance of an export. Now, it's fairly unusual to see the regulators put that level of sanction on a company, particularly a company isn't aware that it's violating the export laws, but it's possible. Another type of sanction is very harmful to a business, and that is if you've been servicing a client that has your product in violation of the export laws, you're no longer allowed to serve and provide any sorts of service to that company until you are square with the regulators. And so that can have a very deleterious effect on your relationship with your clients.
Alex, talk to us about the importance of export law compliance in the context of major financing events where technology companies raising capital or raising private equity, or importantly, where they may be selling the company. How are the issues arising, and how can they trip up a company in moving forward with the transaction?
John, I think it is more often the case than not that companies discover that they're not in compliance with the export regs during the course of a due diligence process before, for example, either a major financing event or an acquisition. And that's often where the concept of export reg compliance comes up for the first time, and it can have a serious impact on, for example, in a funding event, on the valuation of the company that is looking for the funding. In the case of an acquisition, a common result can be that the buyer of the company will ask for a very, very high escrow amount in the event that there are problems that arise after the closing based on the non-compliance with the export regs. So these are absolutely critical compliance steps the company should take before considering a major funding event or transaction or other liquidity events such as public ownership.
Alex, I appreciate your time. You clearly are very involved in this, and I know you've been involved in both export compliance considerations in the context of counseling companies, as well as in the context of these corporate finance transactions, M&A deals, private equity, and the like. And I think maybe the best advice is to get these issues addressed early on, as opposed to waiting to a later point when you might have the sanctions involved. So thank you.
You're very welcome, John. It's a very important step in the overall compliance obligations of a company.
Thank you.